You asked for additional potential citations to authority, Your Honor. I would tender one, McKee, M-C-K-E-E versus State. That is 712 Southern 2nd, 837. Generally standing for the proposition that evidence relevant to a witness's possible bias, prejudice, motive, or intent is nearly always necessary to inform the jury of any motives regarding, in this case it was a prosecution witness, but I think it applies equally. So again, in addition to the Britton case that I cited, the evidence would be admissible for that purpose.
But what about the rule, the evidentiary rule that you can't call a witness for the purpose of impeaching?
Well, I'm not necessarily calling him to impeach him, because impeachment would mean that I am contradicting some of his earlier testimony. I am perhaps calling him to impeach the testimony of Mr. Root, but that's not calling him to impeach this witness. If this witness denies or says something that is contradicted by the actual written record, then it may be necessary to impeach him, but I don't think he's going to deny that that's on his website. He may offer an explanation. That wouldn't be calling
what is within the website that would contradict any evidence offered by Mr. Root?
Well, I don't know that as far as contradicting, he said that I believe he characterized Mr. Pollack as uninterested or unbiased, or one of those, that characterization, I forget the exact word he used, but that he placed extra weight on his consultation for that reason. So it would not necessarily just contradict. I think it's also either contradict or help explain.
Okay, defend.
It has to, if it's impeachment, it's impeachment, and it has to impeach something. So let's talk about what it's being presented for. And we read from the same Bible, so I looked at Earhart for some insight on this, and what he says is that it actually has to be relevant. It has to truly impeach or address an issue of bias. In effect, if what we're looking at is this witness's, Mr. Pollack's bias, and how he may have presented in a way that evidences his own personal financial interest, which I guess is the underlying request of the state, that they impeach, or make believe not impeach, but impeach this witness by saying, you might be trying to make money on Mr. Zimmerman because he came to your gym. Let's just think this through for a second, and I think the court has to include within its context of authority common sense. So let's look at it through common sense filter for a moment. This witness who wants to tell somebody to come to his gym because I trained Mr. Zimmerman got in front of this witness, in front of this jury, and under oath said he went from a 0.5 a year when he first got to me to maybe a 0.1. That he was soft then and he's soft now. There's no financial interest that this witness furthered by his testimony, and that's why it's sort of bizarro impeachment, because it doesn't impeach what it would normally impeach. If this witness came in and said, this guy is great, and because of my training, he can kick anybody's butt, then maybe I would come in and say, wait a minute, aren't you making money by saying that you do a great job? We don't have that. We have the opposite of that.
Okay. What we have here and what the state had cited to the court was Britton versus State, 414 Southern 2nd, 638, and it is a 5th District Court of Appeal case. And in that case, the state didn't call this witness in their case in chief and called him in their rebuttal. And the court indicates that rebuttal evidence explains or contradicts material evidence offered by a defendant. And the testimony delivered by the state's rebuttal witness was neither explained nor contradicted any evidence offered by the defendant in that case. Permitting the testimony, however, was not error because the court has discretion in the order of presentation. What you're trying to do with Mr. Pollack is not an order of presentation. It is to impeach your own witness. You're calling him as a witness to impeach him by saying that he's advertising on a website about the Zimmerman trial and the Zimmerman training that he received at the gym. I don't think that that's allowed, and I'm going to sustain the objection.
Very well, Your Honor.
So I don't know how you want to handle this in front of the jury. We could tell them that Mr. Pollock is not going to be testifying, and you could call your next witness. Or we could have him come on here if you have any other questions that you wanted to ask him. This was the sole purpose?
Yes, Your Honor. I was going to call him and ask him about that particular website advertisement.
All right. Well, then the state agrees based upon the court's ruling. There's no reason to have Mr. Pollock come back into the courtroom?
Yes, Your Honor.
All right.
The next witness similarly has some objections to the presentation. May as well take that up before the jury comes back in, if we could.
All right, and the next witness's name is, please?
This is Mr. David Lee, Your Honor.
All right, and what is the purpose for calling Mr. Lee?
Judge, could I have just a moment?
Yes, you may.
Mr. Pollock is going to be released from his...
Yes, Mr. Pollock will be released.
Judge, on balance, the state is not going to be calling Mr. Lee.
Right, and how about the other witness that the state was going to check on for tomorrow?
I haven't left the courtroom to be able to check on that, Your Honor. I haven't yet known.
Surprisingly, we have an objection to the presentation of that evidence as well, maybe to address it.
Maybe we can proffer it. What is the name of that witness?
He is Mr. Fleischman, Your Honor.
And his first name?
I believe it's Arthur.
Arthur? And what is the objection to that?
Who is he? He is the agent with the Bureau of Alcohol, Beverage, and Tobacco for whom the defendant was arrested for committing a battery on a law enforcement officer. That is who he is.
Okay, and the purpose for calling him?
Because the defense has gone to great lengths to assert that the defendant is, despite all the other circumstances, largely incapable of fighting. I think this agent would offer a different perspective on that, where he could be permitted to testify. Specifically, he would essentially say that while he and some of his fellow law enforcement officers were engaged in arresting some persons at a bar at which the defendant was, that they had the individuals outside subject to being arrested, and the defendant came out. One of them, or at least one of the people being arrested, was one of the defendant's friends. The this agent in particular will say that he identified himself to the defendant, showed him his badge and identification, told him that he needed to leave while they were effecting the arrest of these individuals, and the defendant actually attacked him. That would be his testimony.
My response, John? One, it's a prior bad act that the state is trying to get in improperly, firstly. Secondly, of course, there's a 403 analysis that needs to be done by this court. Thirdly, you need to probably know a bit more about the facts of the case just so you can address it. The agents were undercover at a location out by UCF and had taken a friend of Mr. Zimmerman's out bodily because
Can I have a time frame in this, please?
It is 2005, Your Honor, so we're talking 8 years ago. Before, just so the court's aware, before he wanted to become a prosecutor, before he got his concealed weapons permit, where they did a background check, before he did the ride-along with Sanford Police Department. The reason why all of that was probably able to be accomplished by Mr. Zimmerman was that in 2005, when these agents grabbed his friend, who seemed to be underage, dragged him outside, and I think they'll probably acknowledge if that's how they accomplished it. Mr. Zimmerman, since they were in plain clothes, I think the officers will say that at some point they brought out their lanyards, but I think this court, previous court, Judge Lester, when he addressed this very same issue, I think opined succinctly that the way that these things are handled out by UCF is that the agents go in there sort of, I don't know if he used the word Gestapo, but something like that. Anyway, so they take him outside. Mrs. Zimmerman goes outside to ask exactly what transpired. The officers didn't like the idea that someone was getting them in their way of what they thought that they were doing properly. And they arrested Mrs. Zimmerman. I never heard that he attacked him. I don't think that's in the police report. Maybe Mr. Manti can proffer the police report to the court. But in any case, he was arrested for battery on a law enforcement officer. That went to the state attorney's office, who dropped it down immediately to a misdemeanor, which you know from your experience they hardly ever do on true police victim crimes. They just don't do it, and they're told not to. Not only did it drop down from the charge to a misdemeanor, but then also opposed to the normal procedure of a case like this, it went into pretrial diversion. Having gone into pretrial diversion, he successfully completed that. They dropped the charges completely. So 8 years ago, he was in fact over-arrested for something. The initial prosecutor review it, identified it as being an overcharge, dropped it down to misdemeanor, pretrial diversion, and it was dismissed outright. It bears no significant probative value, both because it's ancient in time, it's ancient in act, and the way it was handled by the system suggests that it was a non-event even to begin with. I want to make sure that we're clear, however, that if in fact the state brings in this one prior bad act, suggesting that my client is now a fighter or something, that the very witnesses that the state attorney's office has relied on throughout this case, particularly those interviewed by the Florida Department of Law Enforcement, and most particularly the Federal Bureau of Investigation, when they did their "Are you a racist?" interview of everybody who my client talked to, including family members, a lot of people from retreat.
Okay, can you get to your point?
The point is that there are probably 30 witnesses to counter this one witness that my client is peaceful, nonviolent, friendly, mellow, and everything else. Information the state, and the reason why I present it now, information the state is well aware of.
I told you when we were at the bench, I really don't like these, you do this, I'm going to do this argument. Everybody, each side is available to present whatever case that they want to present within the bounds of the law and the rules of evidence, and they do so at their own peril for opening any doors that may be available. So I don't, you all are experienced lawyers, and you know what you can and cannot do, or should and should not do. So I don't want to hear, if you do this, I'm doing that. That will be based upon a ruling from the court as to whether or not any particular door has been opened from either side. Mr. Manti, you have indicated that you don't even know if this witness is available. We now know what information you seek to elicit from this witness, and we can have argument if he is in fact available and you're seeking to have him testify. We can have argument before he testifies. Are there any other rebuttal witnesses that the state would be seeking to call?
No, Your Honor.
Right. Based upon that, I don't know if you're going to have any rebuttal, so we'll wait to see whether or not.
There's been no rebuttal. I don't think it's appropriate.
Well, I don't know whether or not.
If you allow this, I'm sorry.
Right. So we'll take that issue up tomorrow. I would like to then inform the jury as to where we're going in this case. So there will either be some more testimony in the morning. We'll do our jury instructions tonight, finish them up in the morning, and I'd like to tell them that we're going to start closing arguments tomorrow. How long does each side anticipate that they will take in closing?
Since we have opening and closing in terms of, I would say 3 hours.
I presume that only one attorney will be handling closing for the state, correct, as per your normal course?
Well, I think in any other times that we allow another attorney to do the rebuttal, I've always done it that way, so if that's how they choose to do that.
I object.
Okay. Your objection's overruled.
I think 3 hours is certainly enough.
Are there going to be a lot of conversations or rulings having to be made by the court concerning the jury instructions, other than what we do with a self-defense instruction in light of the Supreme Court's review of that instruction?
There's that. There's an addition based upon a case that I've just mentioned to the state but can present to the court as well as Gibbs versus State, which is a slight modification to the self-defense instruction to identify a word that's not otherwise defined. I'll tell you now, I'll tell you when we get together. Then there is the circumstantial evidence one that I think that has certainly been presented to the jury as an existing element for them to consider. And
When do you anticipate having your proposed instructions to both the state and the court?
I told him I'd get it to him tonight, so I'll get him the case law and those are the two instructions. We have some argument on the inapplicability of manslaughter to the facts of this case. I'd like to argue that with you at some point. I think those are the three main, with consultation with Mr. West and my client. There may be a couple of other polishings, but I think that's the
How long do you
focus.
think that argument is going to take on the jury instructions? I'm just trying to get a feel for timing.
Oh, I think half an hour. I mean, I think it's pretty straightforward. Circumstantial evidence is what it is. I think it's discretionary with the court, but when the facts support it, it's allowable, so I'm not going to retrain anyone on that. The Gibbs case just defines provoked because it's not otherwise defined.
Okay, and if you're not ready to present that to the state yet, I'd rather wait for the argument. I'm just trying to get a scheduling idea right now. If I were to release the jury to recess for the evening and bring them back at 10 in the morning, the state can start their 2 hours, if there's not going to be any further rebuttal, could start their 2 hours portion of their closing statement. They could go to lunch. The defense can do their 3 hours and the state can do their hour rebuttal, and we can get it to the jury by tomorrow evening or have them recess for the evening and come back Friday morning. I'm going to leave it up to them as to how long they would like to do that for. So
is now an opportunity, maybe after the jury's released,
to do the Donnelly hearing also.
to do Donnelly and also to address the issue of their rebuttal. And the reason why I suggest that now rather than tomorrow is if you allow that, we may well have, I don't want to use the quid pro quo argument to you, but that's going to take a lot of work to get rebuttal witnesses together, a great deal of work, including all the other witnesses to that event and the other.
Well, none of this may even occur if that witness is not available. Is there any way that you can let this court know sometime soon whether that witness is available at all?
Yes, Your Honor, I'm trying to check now, actually.
It may be a non-issue.
Okay, then we'll wait and see if we need to have the argument, I guess. Okay.
Let's go ahead and bring the jury in, and I'll excuse them for the day, and then we'll begin on Donnelly. Go from there.
Before they come in, you are also then going to address the argument of whether or not that door has been opened before they begin their rebuttal and whether or not it's appropriate. I just want to make sure that's not waived.
Nothing has been waived. I just want to know the availability of that witness because none of it may be an issue.
Yes, Your Honor. So the court's clear as to coming in. We did file the judicial notices on the
Jury's present, Your Honor.
pleadings and exhibits. They're in.
I need to make sure that we need to
Please be seated.
please do it too.
Ladies and gentlemen, again, we have some more work that we need to do outside your presence, and instead of keeping you back there in the jury room, I'm going to let you recess for the evening. I just wanted to tell you the state of where we are. I hate to ever tell anybody what I anticipate will happen because as soon as I say it, something else occurs. But we do anticipate to go to closing statements tomorrow. And since there'll be some more work that we would have to do in the morning, I'm going to have you come back at 10 a.m. So it gives you a little bit more time in the morning. When I have you recess for the evening, I want to give you the instructions. During the overnight recess, you're not to read or listen to any radio, television, or newspaper reports about the case. You're not to discuss the case amongst yourselves nor with anybody else. You're not to use any type of an electronic device to get on the internet to do independent research about the case, people, places, things, or terminology. And you're not to read or create any emails, text messages, tweets, social networking pages, or blogs about the case. Do I have your assurances that you will abide by these instructions? With that, put your notepads down, follow Deputy Jarvis, and have a good evening. Please be seated. What's been handed to me as State's Exhibit 213 is that the correct
That's
exhibit.
the replacement, Your Honor.
Okay, both sides agree? And then I've been handed Defendant's Exhibit 40, which is the weather report for February 27th. Both sides agree?
Yes, Your Honor.
Then you are going to look at Defense Exhibit 39. Is there any objections to that,
Judge,
Trish?
they emailed it to me a few minutes ago. We're verifying it, so there shouldn't be, but I just want to verify it, so it may take a little bit longer because they revised it and we just need to check.
All right. Are we ready to proceed about the state's motion for sanctions regarding Mr. Donnelly?
Yes, Your Honor. Your Honor, previously the state had filed a request to have Mr. Donnelly's testimony stricken, in part due to the discovery violation that was asserted based upon his radical change in his testimony. And while the court found that there had in fact been a discovery violation, you found that the state had failed to establish enough procedural prejudice under the Scipio, S-C-I-P-I-O case, and as well as Evans and Cassica that we had discussed at that time. And so the request for any curative measure at that time was denied. However, I did indicate to the court that we believed that there was some indication that the witness, in addition to that discovery violation and change in his testimony, had apparently been present in court. I did not have the confirmation at that time. However, I have since obtained it. We did provide counsel, and I believe the court as well, copies of photographs, essentially clips from videos. The witness, Mr. Donnelly, was in fact present at least 2 days of the court proceedings, that being the 25th and 26th of January, seated with or immediately behind the defendant in the defendant's family section, and is captured on those screens and is present. I don't think there's even any real dispute that that is him. My understanding is that the concession is that it is in fact that witness. It is subsequent to his sitting through 2 days of testimony, which included a number of witnesses, including Diana Smith, the crime scene tech, and significantly Jane Serdyka, who identified the voice that she heard screaming as a younger man's voice, a boy's voice, I think was her word, something to that effect. Following his presence in court, the witness went home on the weekend, decided to listen to the tape, contact Mr. O'Mara, and we know the history from there. I will point out that even since that time, we have learned that similar things have happened with 2 additional witnesses. As we learned yesterday during the testimony of the defense witness, Mr. Shoemaker, witness John Good, who remained under subpoena and subject to recall, actually met with defense counsel as well as Mr. Shoemaker to discuss and address and adjust and therefore change the defense animation exhibit. Further, right here today, we heard from Miss, you'll have to forgive me, Bertalan, who also indicated that she was present and had watched, or maybe not present in court, but had watched and participated, had watched and observed at least a portion of the trial proceedings, including the testimony of, I believe she said, the defendant's uncle. And so we have, I think, established now, as far as procedural prejudice goes, that the witness in question, Mr. Donnelly, subsequent to sitting in court for 2 days, took it upon himself, I think is his representation, to go ahead and do something which turned him from as the case law indicated earlier, a non-witness into a witness. And Mr. Good certainly was in contact with and discussed potential testimony as well as actually a defense exhibit, again in violation of the rule of sequestration. As it relates to sequestration, I think that the relevant case law as it relates to what to do about potential violations of that rule is set forth in the 4 cases I provided to Your Honor. Again, I think the Scipio and Evans and Cassica line of cases indicate that there does need to be some showing of procedural prejudice. I think the change in testimony as well as the discussions had with Mr. Good in particular, as well as to a lesser extent the third witness that we heard from today, Ms. Bertalan, certainly the cumulative effect of all of those are the ones we know about at this point in time, have sufficed from the state's perspective to establish that there has been some procedural prejudice now, sufficient for that. As far as the violation of the rule of sequestration, obviously the court has contempt powers over and above and independent of any of this. However, the cases that I've cited to the court are, first off is McKinsey, McKinzie, which is the first DCA case, 845 Southern 2nd 316. And the first issue or the first order of business is to determine whether or not a violation was with knowledge or consent or connivance of the defendant or his counsel. I believe as to Mr. Good, the representation I've heard is that certainly that was with the knowledge of counsel. I don't know, I think the representation as to witness Donnelly has been that that was without necessarily the knowledge of counsel, although whether defendant or any other member of his family knew, I think is certainly open to question given the location in the courtroom that the witness was observed. Second issue is if it is not with such knowledge, connivance, or consent, then the second way to determine this, and I'm reading from page 2 of the court's copy at the bottom of the left-hand column, second test to determine whether a sequestration violation should preclude the witness from testifying, and the state's position is since they've already testified, the remedy is, at least as to Mr. Donnelly, the prior request to strike his testimony and give a curative instruction, was put forth in Steinhorst versus State, that's S-T-I-N-H-O-R-S-T. The Supreme Court restated an earlier holding from a case called Dumas, D-U-M-A-S, further explained that the test to determine whether to exclude a witness is whether the sequestration violation changed the witness's testimony from what it would have been had the rule not been violated. So again, before I get to the other cases, the change in the testimony, certainly there's been a change in the exhibit, the animation, as testified to by Mr. Shoemaker, and I think Mr. Donnelly's change in testimony is pretty radical and pretty evident. He went from testifying in his deposition that he hadn't heard anything and didn't recognize a voice to testifying at trial that he had heard something now and did recognize a voice. The next case is Scott versus State. That's 17 Southern 3rd, 766. It's a case from the 4th DCA. And I believe it's referenced as page 4 of the opinion in question, or the copy. I'm sorry, beginning on page 3 and continuing on to page 4. But beginning on page 3, in this scenario, there was a defense witness who was present in court and then opted to express her desire to testify. She was attempted to be called by the defense. The court ruled, much like this court has ruled, that there had been a discovery violation. I don't know that this court has yet determined whether that was willful or substantial, but the trial court in Scott did, and expressed concern about the violation of sequestration, and then said that the court believed and found that the defendant was not acting in good faith, but purposefully trying to thwart the prosecution, including dropping the witness on the lap of the prosecution at 1:30 yesterday. I think the court's comments in that case are illustrative. The court said, I'm mindful of the law, but I think that Mr. Scott has been knowingly and intelligently making certain decisions in this case to his advantage and to the prejudice of the state, and to allow this witness to testify at this time would be, and the court finds, will be prejudicial to the state. The court found that a Richardson discovery violation, and there is prejudice to the state in this matter that cannot be reasonably overcome based on the totality of circumstances. The court goes on to say, at the bottom of that column, although the rules authorize a trial court to exclude a defense witness because of failure to disclose the witness, the law has well established the exclusion of a witness is a severe sanction, which should be resorted to only after the alternative available remedies have been fully considered and deemed insufficient. In this case, as to witness Donnelly, there is literally no way to unring that bell other than a curative instruction and instruction to disregard his testimony. So while we recognize that what we're asking for here is not quite the nuclear option, but a severe sanction, I believe the case law supports that it can be done. The Scott court approved that in that scenario. The next case in order is Steinhorst itself, which is the Florida Supreme Court case from 1982. It begins on, I believe, page 7 of the copy of this court's opinion. At the very bottom, head notes 8 and 9, where they're again referencing the old Dumas case. And they indicate that Dumas does not outline the circumstances under which a court may properly exclude a witness for violating the rule. The test, however, is whether the testimony of the challenged witness was substantially affected by the testimony he heard to the extent that his testimony differed from what it would have been had he not heard the testimony in violation of the rule. Defense counsel in that case tried to show the testimony of the witness may have been affected by what he heard. The state attorney elicited testimony contradicting this. The court made a determination in ruling. Finally, the Dumas case sets forth the older test, still valid, but as I think Scott made clear, only one of a couple different possible ways. On page 2 of the opinion, in the right-hand column, if the witness disobeys the order of withdrawal while he may be proceeded with against for contempt and testimony open to comment to the jury by reason of the conduct, he is not thereby disqualified, and the weight of authority is that he cannot be excluded on that ground merely, although the right to exclude under particular circumstances may be supported within the sound discretion of the trial court. Your Honor, the state's position is that we believe, given both the nature of what went on, particularly as to witness Donnelly, to a little lesser degree witness Good, and to a significantly lesser degree Ms. Bertolin, as well as the cumulative nature of it and the radical change that occurred to both witness Donnelly's testimony as well as the exhibits and items discussed by Mr. Good in connection with Mr. Shoemaker's testimony. The state believes and would renew our request. Obviously, the court can proceed in any fashion it wishes via contempt proceedings against any of the three witnesses, but we would renew our request as to witness Donnelly that the court issue a curative instruction to the jury and order his testimony stricken or a combination thereof. Thank you.
If I may, Mr. Manti, if I might approach Your Honor with some case law supporting different conclusions. I don't know if we're now opening the door, so to speak, to all those potential violations. We want to talk about Mr. Good and